SJC-09265, Commonwealth v. Jason Robinson.
Thanks, Fran. Thank you.
Mr. Lynn, good morning, but wait one moment while
Yes, absolutely.
everybody gets set up and Ms. Scapiccio can take careful note of all that you say.
Good morning, Your Honors. Paul Lynn for the Commonwealth. May it please the Court. As you know, this case comes before this Court for the first time 15 years after the defendant's conviction for murder on the Commonwealth's appeal from a ruling by Judge Salinger that the defendant was entitled to the preserved for courtroom closure, even though he did not make a timely objection to the closure at trial. That was a clear error of law and thus requires reversal of the decision. In Massachusetts versus Weaver, and in cases such as Commonwealth versus Jackson and Commonwealth versus Kolonovic, the Supreme Court and this Court have created two clear categories of courtroom closure cases: those where the defendant preserved the issue by objecting at trial, and those where the defendant did not. And I will quote directly from Kolonovic here. This is 478 Mass 203 at note 13. Quote, "The important distinction is not whether the claim was made in the direct appeal or the motion for new trial, but rather whether the courtroom closure issue was preserved at trial." Here, there's no question that there was no objection at trial. What the defendant is trying to do here is create a needless third category of courtroom closure cases where the issue is preserved despite the absence of an objection at the time, where the defendant and his counsel were unaware of the closure, regardless of whether they had reason to know of the closure, unless, of course, the reason for the knowing was that they knew of a routine practice of closing the courtrooms during jury selection, and then only if they did not raise a prior motion for new trial. The Constitution does not require that category, and it would make no sense for this Court to adopt it. It also doesn't matter whether or not the defendant raises its claim as a claim of ineffective assistance of counsel. This Court has made it clear in cases such as Commonwealth versus Randolph and many cases since then. The standard is the same whether the defendant raises an unpreserved issue directly or under the rubric of ineffective assistance of counsel, and that makes sense. If gross incompetence by defense counsel doesn't relieve the defendant of his burden to show prejudice, then certainly mere ignorance does not either. Weaver doesn't say anything, this is the Supreme Court's Weaver case, of course, doesn't say anything to the contrary. The defendant argues that Weaver stands for the proposition that if the issue is raised on or before the direct appeal, then it's preserved. But that's not what Weaver says. At page 1910, Weaver says, claim of structural error is preserved, quote, where there is an objection at trial and the issue has been preserved on direct appeal, or has been raised on direct appeal. And then again at 1913, reversals automatic where, quote, a structural error is preserved and raised on direct appeal. And as I said before, this Court has already ruled in Commonwealth versus Jackson that failure to object at trial is failure to preserve, even if the defendant and his counsel were unaware of the closure. Now, my sister argues that that case is distinguishable because in that case, the defendant had also raised a prior motion for a new trial. But what he really raised was a motion for a mistrial and a new trial based on something that happened immediately, or that came to his attention immediately after the trial, within a week of the trial, or 8 days, I think. And that was that one of the jurors was a non-citizen. Counsel's knowledge hadn't changed at that point. Trial counsel was still completely unaware of the closure. He swore to that in an affidavit, saying, I didn't learn about the closure until I was informed of it by appellate counsel years later. So if that had been a distinguishing factor, then this Court would have analyzed that issue under Rule 30bc2 and said, was this claim available to defense counsel at the time? And it was no more available to him at the time he filed that motion as it was on the day of the closure.
So is the issue here whether or not we speak of the language of waiver? Because I think what Judge Salinger essentially found is that there can't be a waiver of a claim because were not even aware of it. So you're saying it's not waiver, it's failure to object, period, regardless
Period,
of
yes.
whether you knew.
I think that's the distinction that this court and the Supreme Court have made. What Weaver really did was it took all the reasons for why there was no objection at trial and moved it from the preservation side of the analysis to the fundamental unfairness side of the analysis. And what it did is it looks at, was there something about the proceedings? The Weaver makes it clear that the defendant does not have to meet the traditional showing that this might have affected the verdict, because of course, as everyone recognizes, that's virtually impossible. But it does say we will look at special elements of fundamental unfairness. And although they don't, I mean, the one example they give, of course, is where the key witness testifies in secret. Under those circumstances, they said that would be fundamentally unfair, regardless of whether it affected the verdict. But they also indicated circumstances that might create fundamental unfairness in the negative by discussing what happened in that case. And I would point out that all of those factors are present in this case as well. The courtroom was closed only during jury selection, not during the taking of any evidence. This wasn't an act by the judge, it was an act by well-meaning court officers. There was a large venire that, many of whom, the majority of whom were not selected on the jury and thus could view the proceedings. And there was nothing besides the closure, and the proceedings were transcribed so the public knows what happened. And there's nothing other than the closure itself that indicates there was any fundamental unfairness.
Well, I suppose trying to figure out what that language means from the United States Supreme Court. What you have here is a situation where the defendant and the defense attorney don't object
Correct.
to a closure that, at least back, this was maybe 2003 before?
2002, yes, Your Honor.
Maybe before Chief Justice Rouse?
Yes.
Okay. So back then, not only did the attorneys not know, but I expect that most of the Superior Court judges didn't know that the courtroom was being closed while they were in paneling.
Yeah,
I'm just trying to figure out what fundamental unfairness means. So is it fundamentally unfair if there's no chance to object to something that nobody knows about except for some court officers?
No, I don't think it is because of the factors, the kind of factors that the court discussed in Weaver. And they make it absolutely clear. The closure itself is not enough. Neither is the speculation that the jurors might have behaved differently if the public had been there. There has to be something concrete. And as an example, they say there was no improper conduct. I think it would be clear that you would be approaching fundamental unfairness if there was some evidence that the closure was somehow concealed by somebody, concealed from defense counsel by someone official, which was not the case here. Just the officers were well-meaning, they were doing what they'd always done. But that's a moot point here because the defendant was nonetheless on notice that the closures, all the factors were there. The defense attorney said, I knew that courtrooms were sometimes closed during jury selection if there was a large venire. Well, here the record makes it clear there were 79 people in that courtroom. That's a large venire. Now my sister says, well, we don't know whether that filled every seat. That's not the point. That's more the Waller analysis of whether or not this would be justified. The issue is defense counsel could see that there was a large venire and thus the court officers might have closed the courtroom. There's also evidence on the record that the first venire was entirely exhausted by the afternoon, and the judge says, you can see from the empty seats that we need a new venire. So at that point, it would have been obvious that there were no spectators in the courtroom. The judge even found the only reason that the defense attorney didn't notice that is because he was intent on, on the process at hand. He wasn't looking behind him. And perhaps most important is that this is in a situation of unfairness because defense counsel admitted that he wouldn't have objected, that the knowledge of the closure wouldn't have changed his course of conduct, except that he might have tried to make some accommodations for the defendant's family, although most of the people outside were members of the co-defendant's family, so it's not even, or any of his supporters, so it's not even clear he would have done that. But that's academic. The point is that he would not, the knowledge of the closure would not have changed his behavior in any way. And I would point out that the defendant has not cited a single case that is still valid, that has been come down since Morganti and Aylward, let alone since Weaver, in which a court has reversed a courtroom closure, a conviction on courtroom closure grounds where the defendant did not object at trial. The two cases she does cite are the two First Circuit cases, Owens and Negron Sostra, but the Supreme Court explicitly overturned Owens in Weaver, and in Negron Sostra, the court said explicitly that they were following Owens. So neither of those cases is valid, which lends further credence to the fact that this is solely an issue of preservation at trial.
And there's a reason for it. The reason for it is it's easily correctable and not necessarily something that the judge is going to discern on his or her own.
Correct. That's why it has to be brought to the judge's attention. And I think, are there any further questions on the preservation issue? Because I do want to go to the prejudice briefly, because the defendant does raise it and did raise it below. The defendant argues correctly that this is an important right. There's no question, and the Commonwealth never said it wasn't. What the Commonwealth said was that it is not as important, relatively unimportant compared to other rights, such as the right to an attorney, and that's exactly what the court said in Weaver. And I quote now, this is 1908, page 1908, "An error can count as a structural error even if the error does not lead to fundamental unfairness in every case." And then again at 1910, "While the public trial right is important for fundamental reasons, in some cases an unlawful closure might take place and yet the trial will still be fundamentally fair from the defendant's standpoint." And I think in that way the court rejected the analysis of the First Circuit that the defendant has the right to vindicate everyone's right in the public trial context. There's no question that this right belongs to other people besides the defendant. It belongs to the press. It belongs to the public. But what the court made clear in Weaver is those aren't the defendant's rights. The defendant's right is his own right, and he has to preserve it. And again, I'll point out as I did before, all of the factors that the Weaver court cited to say that there was no fundamental unfairness in Weaver are present here too. Yeah. If there are no further questions.
Yeah, I'm a little bit confused by the last point. Are you saying that if there had been, if at trial, the attorney had said, "Your Honor, the courtroom is closed, it should be open," and the judge had overruled that objection, that we would be able to sustain the conviction because it was not fundamentally unfair to do so?
Oh, no, that's entirely wrong. There's no question. If the defendant preserves
You're
it.
not challenging the idea
Right.
of structural error.
It's the situation would be one like in Negron Sostra, where the defendant approves of the closure, and the court said no because the judge still had a duty to keep the courtroom open. It's their other rights at stake. And what Weaver says is, the public right is important, but it's the public's right. And that's illustrated by the cases I cite in my brief, both Press Enterprise and Brown. Press Enterprise, of course, is the Supreme Court case where they held that the judge couldn't close the courtroom to the press. Brown is the actual defendant's case in that case, where his conviction has been affirmed, as I point affirmed, not infirmed, has been affirmed. As I point out, there's been all sorts of case law on his death penalty. But the fact remains, to this day, his murder conviction remains intact, even though the courtroom was closed to the press.
Mr. Wynn, one question. I'm trying to find, there are two cases where we talk about inadvertent, that even when it's inadvertent, what are those cases?
Jackson and Wall, Your Honor, are the two cases where you talk about inadvertent.
Do you have the quotes from those? Do you know where they are, the exact language in both of those? Because
It's on the same page, I believe, as the the quotation I take from that case, if you just give me a second, I can
Yeah,
look
if
it
you
up.
could just, I just want to, because I'm going to, once your sister stands up, I'd like to talk to her about those, but I just can't put my fingers on them right now.
I believe they're on the same page as the language I quote in my brief, but I can double check that if council doesn't bring it up.
Okay.
Are there any?
Just picking up on Chief Justice Ganse's last point. So you agree that if the objection is preserved, that there's no requirement of prejudice?
None at all.
Okay. Thank you.
Thank you, Your Honors.
Thank you. Ms. Capiccio, good morning. Good morning.
Good morning, Your Honors, Chief Justice, Associate Justices. My name is Rosemary Scapiccio, and I represent Mr. Robinson in this case. Here, we were successful on a motion for a new trial in the Superior Court. Commonwealth's burden was to prove that there was a significant error of law or an abuse of discretion based on the evidence that Judge Salinger heard. And Judge Salinger was very specific about the evidence that he heard. The only witnesses that were called in this case were witnesses for the defendant, in which all indicated that they had been excluded from the courtroom at the request of the court officers. The Commonwealth called no witnesses, didn't call any court officers, didn't call any lawyers, didn't call anyone to establish that in 2002 there was a common practice of having excluded the public from the jury selection process. They submitted 2 affidavits that said in 1998 there had been a practice. And Judge Salinger was very clear that he did not believe he could take judicial notice of what was happening in 2002, when the only evidence presented by the Commonwealth was the evidence of what happened in 1998. And that's the evidence as he had it. He had affidavits from Mr. Robinson saying that he didn't know. He had the trial test or the motion testimony of Mr. Doolin and several other family members and friends of the defendant saying they had been excluded. And he based the determination on the credibility of those witnesses.
So assume that we're going to take those facts and apply the doctrine. How's the doctrinal framework allow the decision of Judge Salinger to be affirmed?
Well, I think it turns on the definition, or the Supreme Court's definition of fundamental unfairness. And I think it's incumbent upon this court to tell us what that interpretation is. If it's what the Commonwealth wants this court to do is say whether it's a straight Sixth Amendment argument or an ineffective argument, the failure to object is fatal to a defendant's argument. That's the position that they've taken.
What about this line from Justice Hines' decision? Further, the right to a public trial may be procedurally waived whenever a litigant fails to make a timely objection to an error. A procedural waiver may occur where the failure to object is inadvertent, in Commonwealth versus Wall.
And that's in the context of an ineffective assistance of counsel argument where you have to prove prejudice. This is not an ineffective argument. This is a straight Sixth Amendment structural error claim. There's no claim here of ineffective assistance of counsel. The claim merely is that Mr. Robinson's right to a public trial was violated because the courtroom was closed during the jury impanelment process. There's no question that happened. There's no question that it is a structural error. The question is.
So the standard will differ if it's an ineffective assistance. One, you should be objecting to a closed trial, but if you don't, it's ineffective. And if we look at ineffective, it can be inadvertent. But if we look at it without that prism, it's automatic. I'm confused by how that would work.
Well, I think that's what the court says in Weaver. In Weaver, what the court says, in the direct review context, which is where we are now, the underlying constitutional violation, the courtroom closure, has been treated by this court as a structural error, an error entitling a defendant to automatic reversal without any inquiry as to prejudice, when a structural error is preserved and raised on direct review.
But this isn't preserved.
But-
It's not preserved at trial at all.
Well, it's not preserved because it wasn't known to the defendant. But if I can just finish that, because I think it's
Go ahead.
important to finish. So it says, when a structural error is preserved and raised on direct review, the balance is in the defendant's favor, and a new trial generally will be granted as a matter of right. When a structural error is raised in the context of ineffective assistance of counsel claim, however, petitioners must show prejudice in order to get a new trial. the Supreme Court has said, if you raise it as an IAC claim, an ineffective claim, you're required to show prejudice. This court now has to determine if you don't raise it as an ineffective claim, if you raise it as a strict Sixth Amendment structural claim, is there still a requirement to show prejudice?
If
And
it's
what?
on collateral review.
I'm sorry?
If you're doing a motion for new trial on collateral review, is that what you're talking about?
This is a direct.
This is direct from the motion for new trial.
Right. So there has not been a direct
So
appeal
you've never
yet.
had the plenary review yet?
Never.
So, okay.
And so that's what makes this case very unique. That's what makes this case different. And I think that's what Judge Salinger found when he evaluated, could you waive a right that you weren't aware of? And I think the cases that the Commonwealth cites in terms of waiver, for the most part, they're telling this court that in the context of an ineffective assistance of counsel, when do you waive? There's not a case out there that says, in the context of a straight Sixth Amendment right to a public trial case, what is waiver under those circumstances? What does the court mean, the Supreme Court, when they say fundamental unfairness?
Can we talk about the timing issue, given the fact that the defendant didn't bring this up until 14 years after trial?
It has been 14 years.
Right.
The defendant has not done his direct appeal. That's not something that the Commonwealth argued or brought to the judge's attention. In fact, Judge Salinger mentions in his decision that the Commonwealth doesn't raise that issue at all. So that's a non-issue. It hasn't been raised, it hasn't been argued, it hasn't been litigated in the Superior Court.
Why, we can't look at that?
Well, I don't know what, they'd have to prove that it was intentional. I think that's what the court says. In order to prove that, I would have to have been clairvoyant to know that the court was going to make these determinations and have intentionally waited to raise this issue with the Superior Court. There is absolutely no evidence to that effect whatsoever. And again, it goes back to the Commonwealth. They had the obligation and the right to raise whatever evidence they wanted to at a motion for new trial. They chose not to. They didn't even raise the issue. It was Judge Salinger in his decision that raised the issue of the length of time that it took and the fact that the Commonwealth hadn't objected and hadn't claimed that that was in any type of waiver. That's the first time that it became an issue, is in the decision when Judge Salinger brought it up. To that point, it was never raised and never addressed, and I think unfair of the Commonwealth now to try to raise it for the first time on appeal. An issue that's not raised down below is waived. They've waived it. It's not an issue for this court to consider in our position. And with respect to what Judge Salinger did in making this an evaluation of what is fundamental unfairness in the context of a straight Sixth Amendment review. He looked at the waiver issue, and he made some determinations and findings with respect to the waiver issue. He found that trial counsel, in this case, that trial counsel didn't know that the courtroom was closed.
Right. I'm still a bit confused by your argument. Let's assume that we accept all of Judge Salinger's factual findings.
Yes, sir.
The issue of fundamental unfairness does not go to counsel's conduct, it goes to the closing of the courtroom.
Yes.
But even if counsel was aware of it and had said, I don't plan to object, the courtroom would still be closed, but we have not, and Weaver does not say that that's fundamentally unfair. So why does the fundamental unfairness depend upon whether counsel was aware that the courtroom was closed?
Well, I think in a straight Sixth Amendment violation as opposed to an ineffective violation, the way that this is raised for the first time on direct appeal, the Supreme Court said, if you object and it's raised for the first time, you automatically get structural. That's over here.
Right, and you even agree with him on that.
I do. I think that if you object and it's raised for the first time, it's structural error. There's no doubt about that.
Right.
We're over here and saying, if you don't object, is it always a requirement to prove prejudice? And what the Supreme Court said is that you were required to prove prejudice only in the context of an ineffective assistance of counsel argument. That's
Okay,
what that quote said.
I get that.
And so
And you're trying to
we're
carve out
imposing
some third way.
Well, we're imposing a prejudicial requirement, the same standard, the ineffective assistance of counsel prejudice standard, on a defendant who's not raising ineffective
But
assistance.
counsel, ineffective assistance comes from the same amendment, correct? The Sixth Amendment.
Just a different.
So it's really not the difference between a Sixth Amendment and an ineffective claim. They're both Sixth Amendment claims.
Right, but one is raised as a fault of the attorney. The other one is raised as a right of the defendant for a public trial.
Oh, right. So, but how does that fact that the origins or the purity of the Sixth Amendment factor into this then? What's the difference? I see what you're saying, but I don't understand.
Well, I think that's the question that this court has to struggle with is the difference. What does the Supreme Court mean when it says that a straight Sixth Amendment claim that's not an ineffective claim, if they wanted to impose that requirement that prejudice must be shown, then how do you justify what they say? How do you justify them saying that when a structural error is raised in the context of an ineffective assistance of counsel claim, however, petitioner must show prejudice in order to obtain a new trial? If they meant that you had to show prejudice all the time, no matter what, then what's the purpose of that portion of the decision? They make a distinction between defendants who raise it for the first time on direct review as a straight Sixth Amendment closed courtroom issue and those who raise it as an ineffective claim.
There's an in-between possibility. So
Well, I'm sure there's an in-between possibility, yes.
There's three categories, and two of the categories you both agree with. The first category is preserved. The second category is ineffective, you got to show prejudice. The issue here is you have to show something for fundamental unfairness, and Mr. Lynn told us what he thinks needs to be shown for fundamental unfairness. There has to be something shown. Fundamental unfairness is not enough for a reversal because you have to show, well, what is it that was fundamentally unfair and what standard applies? What do we have for an answer from Weaver for that?
I think that Weaver says that Weaver only defines two different scenarios, the structural error scenario and the ineffective scenario. And we're in a gray area in the middle. We're saying that it's enough. The way that Judge Salinger decided this case, he went through the waiver issues and came to the conclusion that there could not have been any waiver in this case because if there was, if the rule is you always have to show prejudice, if it's not just a structural error that doesn't require a showing of prejudice, then you'd never be able to meet that standard. And that's the evaluation that he did. Yeah. He went through and said that there's no doubt in his mind that the attorney didn't know. He went through and said in this case, based on these facts, there was no determination that it was common practice at the time. And the defendant raised it for the first time on direct review. Well, meeting all of those standards, it's structural error.
But to give you a shot here, I mean, I really don't think that's going to be how it works out. I think that fundamental unfairness is not going to be tied to whether or not the waiver was reasonable or unreasonable and who knew or who didn't know. Fundamental unfairness is going to be something about what happened with the closed courtroom that had some sort of, not necessarily changed the verdict, but had some sort of an impact on the proceeding.
Well, if you're looking for something specific as to Mr. Robinson's case, then all I would suggest you do is to reread the impanelment. If you reread the impanelment, you will see that the challenges made by the different attorneys in this case are not clear on the record. It's not clear who's challenging, what challenge they're making, or what reason they're making those challenges for. None of those sidebar conversations are recorded in this case. And so you're not able to determine whether it's the Commonwealth that's challenging or the defendant that's challenging, and so we're not able then to make a record of that. So if you're looking for a reason, a fact-specific reason, that would be the only one that I could come into contact with. But what I'm saying is that if it's a structural error, then there's no reason to prove prejudice. And you're holding a defendant, or at least the Commonwealth wants.
But you're not, I see a fundamentally different world between, when someone complains, you obviously want to keep the courtroom open. And we've now decided that even inadvertent waiver, again, in the ineffective, but bear with me for a second, because I want to underlie a principle why a Sixth Amendment claim is going to be treated differently, inadvertence is going to be treated differently in one context rather than the other. What's the reason for that? I get, let me just set it up for you, and I don't mean to cut you off. I understand if a lawyer objects and says, I want the trial open, we want that trial open unless there's some compelling reason not to. But when we've said in the ineffective, even inadvertent waiver, you lose. So why do we now have this category where basically, no one's objected, no one's noticed the problem, and now we're going to treat this as structural error. Tell me the principle for that.
Because you would be putting an onus on a defendant that belongs on the court. That's the bottom line. The obligation to have a public trial is the obligation of the court, not of the defendant.
Well, we
If you
haven't done that.
require the defendant
We
to
haven't done that in the ineffective assistance area. So why would we do it? Why would we reach the opposite result here? If we've already, because why wouldn't we? Why would we have that standard for ineffective assistance then? Because isn't that a burden shifting in that area too?
No, because when you raise an ineffective claim, by its very nature, you have to show prejudice. When you raise a straight Sixth Amendment public trial claim, our position is you don't have to show prejudice because it's a Sixth Amendment structural error. In this case, imposing that duty on a defendant, and that's essentially what this court would do. If outside of an ineffective claim, if you're imposing a duty on a defendant, now it's the defendant's job to make sure the court is doing their job while they're paneling on a first-degree murder case. It shifts the burden unnecessarily to the defendant because the case law clearly says the burden is on the court to make sure that the proceedings are open to the public. That's not a burden that the defendant carries. If you decide this case the way that the Commonwealth wants you to, you are then imposing an additional burden on a defendant to ensure that the public is allowed into the courtroom. And that's not a burden on anyone that's been imposed on a defendant.
You're imposing a burden to show prejudice, that somehow it made a difference in the trial. That's what they're doing. Right. I mean, because like when someone complains and says, I want a public trial, you've expressed that. Here we're saying, when no one said anything, and I understand your point that it's the court's responsibility to keep that courtroom open, but there's been no indication it's had any effect whatsoever on the defendant, because the defendant didn't notice it, no one noticed it.
But that doesn't make it less of a violation of his rights. The fact that it wasn't noticed doesn't make it less of a violation.
Why is it unfair? Well, how's he been harmed by it?
But that's the point. You're looking for him to prove prejudice. You're imposing upon him an obligation.
What's the difference between prejudice and fundamental unfairness?
I think the difference is that prejudice requires the defendant to prove that he's been harmed in some way. Fundamental unfairness is this court looks at the entire proceedings and determines whether or not, if you're protecting the Sixth Amendment right to a public trial, should you impose a duty on the defense attorney to do the judge's job. That's what this court comes down to. If there are no further questions, I would rest on my brief.
Thank you.
Thank you.